All right, to this story now. The trial of Senzo Meyiwa's alleged killers resumed this week after 6 months break. And it was not without drama. Disbarred advocate Malesela Defo showed up requesting an audience with the judge. Defo used to present accused 1 till 4. Meyiwa's friend Mthokozi Sithwala has been giving evidence this week. The soccer star was shot dead in 2014 at the home of his girlfriend Kelly Khumalo. Let's discuss what's happened so far in court with attorney Zola Majavu. Mr. Majavu, thank you very much for your time. Let's just start with today's developments, the arguments that have been brought up by the defense after the state said that it's done with its evidence in chief with Mthokozi Sithwala, but it would like to re-look at some of its own witnesses' inconsistencies. This is why we've adjourned early today. According to you, what is allowed and not allowed in terms of the state wanting to re-examine its witness?
No, there's absolutely. Firstly, good afternoon, Maseko, and good afternoon to the viewers. Firstly, there is nothing wrong in any party that has led its witness in being afforded a further opportunity after the cross-examination by the other to do what is called a re-examination. Typically, what happens in a re-examination is where you seek to afford your witness an opportunity to correct certain inconsistencies or certain aspects of his testimony that you think that might not have come across well during cross-examination. The same right or opportunity would be afforded to a defense counsel. Having led their witness in chief, that witness will be subjected to cross-examination by the state. And in the event you are of the view that there are certain issues that need to be clarified, not necessarily inconsistencies, you then have a further bite of the cherry by way of a re-examination. So there would ordinarily be nothing wrong with that process, but the re-examination will happen after the cross-examination has been done by all defense counsel in this matter.
So help us understand how this works. Is it normal for the state to be asking to re-examine now? Shouldn't they be waiting until their witness has been cross-examined first and then ask if they could re-examine? Why is he asking for this to happen now after he said that he's concluded the testimony of Mthokozi Sithwala?
That sounds a bit odd. I must confess, I did not personally watch that stanza of the proceedings, but in terms of normal court processes, he should wait for his opposite numbers in the defense counsel to cross-examine, and then he can be on his feet again to then re-examine and achieve exactly that. But of course, if he is of the view that it is necessary for him to act in that manner, he has to bring an application to the court. And the court may decide to grant it or not to grant it. But generally, what I have explained is the usual process that is to be followed. And I do not want to preempt the reasoning for what might have animated such a decision by Advocate Baloyi. But it doesn't sound to be correct based on how the question was put to me. But I cannot take it further than that.
All right, so Mr. Majavu, let's talk about what happened when this case finally came back on Tuesday. A disbarred advocate in the form of Advocate Malesela Defo appearing in court, asking for the judge to see him in chamber. The judge at some point said, well, you no longer represent any of the accused that are currently in the dock, so I have to find out from the ones you used to represent if they want me to actually hear you out. First of all, a disbarred advocate appearing in court, is that even something that's allowed? And also the fact that, it was brought up that he doesn't represent anyone in the dock.
Perhaps let me state the legal position as opposed to focusing specifically on Advocate Defo. I think the position is as follows. He was, rightly or wrongly, removed from the role of practicing advocates by a full bench of the North Gauteng High Court, which sits in Pretoria. If, like any other party, he is aggrieved by that decision, it is open to him to bring firstly an application for leave to appeal before the same bench, and if granted, that application for leave to appeal, then that would automatically In fact, the mere noting of that application would automatically suspend the operation of that court order, which he is aggrieved by. Now, if the media reports are anything to go by, and if the LPC statement is anything to go by, it would appear that the advocate therefore has not availed himself to that right, which therefore means that that decision, no matter how unhappy or how disgruntled he may be about it, it stands until it is overturned by another court of law of senior status. That has not happened, and therefore he remains disbarred. And if that is the case, he has no business appearing in a court of law, robed in the robes that are preserved for those who are in good standing and who are practicing, let alone wanting to seek an audience with a judge in a matter in which he himself withdrew and his application to withdraw was granted by the judge. He is not acting on behalf of any of the parties. There is absolutely no basis, in my respectful view, that would have given him even the remotest of rights to seek an audience, rock up in a court of law, robed. I think the judge ought not to have even entertained that as a starting point. And I don't want to sound disrespectful to the judge. Maybe he wanted to be fair to all parties, which is why he might have asked his former clients whether or not he should entertain it. But on his own version, it appears that he says he is a watching brief on behalf of the eldest Meyiwa family members, the son, traditionally, as he put it. But even then, on what possible basis could you be a watching brief? Anybody who has an interest in the matter can sit in the gallery and follow the proceedings, be an extra pair of eyes and ears for the family. If he says he holds instructions to be a watching brief, you don't just get requested to be a watching brief, you are instructed. Now, he practices, or he used to practice, as an advocate. Ordinarily, practicing advocates, unless you are a Fidelity Fund certificate holder, ordinarily those advocates would be briefed by what is called an instructing attorney. To jog your memory, a typical Mr. Titi Tobani type. And on that basis of the instruction, then he could appear as a watching brief. A watching brief is indeed passive, but he does have some limited role to play. Namely, in some instances, the court, having recognized his presence, may invite them to comment on a specific issue. But generally, the state prosecutor dealing with the matter, Mr. Advocate Baloyi, is the one who dominates the proceedings. So a watching brief could, at best, pass a note to the state prosecutor, or during the adjournment, share some discussions with the state prosecutor, which the prosecutor may or may not take. But a watching brief is meant to complement that which is done by the state. So the mere fact that he says he holds instructions to be a watching brief seems to go against the very act of disbarment, and it potentially could easily be interpreted as contempt of court. But I don't understand, if he accepts that he is disbarred, he has lost the right to don practicing lawyer's robes and go into a court of law. There would have been nothing wrong if he went to court like you and I would do if you are not directly involved in a matter and you sit in the gallery. And in this instance, he sought an audience with the judge. Now, that right is reserved for practicing legal practitioners. Judges do not, and judges should not be seen to be engaging with you and I as ordinary civilians on a matter that is pending for them. He could have conveyed whatever he wanted to convey to Advocate Baloyi, and Advocate Baloyi would have taken it up with the judge. But before he could do that, Advocate Baloyi would have been entitled to say, on what basis are you even seeking an audience with me, because you are disbarred?
Exactly. I just have to ask you just one more question. I'm hoping, because you're a legal expert, I'm just going to throw this in there, and I'm hoping you can help us. It has nothing to do with the Meyiwa trial. It has to do with the Thabo Bester trial. The NPA in the Free State, announcing that the murder charge that was actually on the docket in terms of all the accused has been removed. Does that now mean anything in terms of their bail application? Will it make it easier for them to convince the magistrate that they are suitable candidates for bail now that a Schedule 6 offence has been removed from the charges?
Firstly, let me remind you that a few weeks ago, when I had occasion to speak to, I think, Braden, I cautioned against the overzealousness of the state and being seen to be cowering under public pressure, because I could foresee that there may be some charges that might have been over hastily added, which, in all fairness or based on objective facts, may be difficult for the state to prove. I have been vindicated. There was no basis in the first place for the state to have even considered charging all these accused with murder. Their own decision not to proceed with that charge has vindicated that position. Secondly, of course, it does have a bearing on the impending bail application. If, for example, they were facing murder and other less serious charges, I would have said the striking off or the non-proceeding with the murder charge would bring them a step closer to a possible successful bail application, because the onus now shifts back to the state, and there is no onus to be resting on them as applicants wanting to be admitted to bail. But it may well be that when one has objective regard to the other charges and the circumstances supporting those charges, it may still not be an easy walk in the park. So it does not automatically follow that they will be admitted to bail. I still think that they have a lot of explaining to do.
Exactly, especially Dr. Nandipha Magudumana. They'll probably argue as the state that she's a flight risk. Thank you very much for speaking to us. Dr. Zola Majavu, he's an attorney and a legal expert.